Hi there, mock trial class. It's Mrs. Chappie. I'm here to give you an update on the Billings versus Pearson trial status. So we've talked over and over again how our trial is kind of like a play and it requires every single person's participation. And we talked on our last time together that there was a possibility that it might have to be canceled if not all students wanted to continue to work on it remotely and independently and through videos and Google Drive and things like that. So the good news is I've reached out to all of the families and I've heard back from 11 out of 18 students, and 11 out of 18 students are all in and want to continue. So super excited about that. I'm still hopeful. I'm reaching out again to the other 7 to see if they're still committed. My hope is that they are, but we're going to go ahead and proceed and move forward as if we are doing this together. So a couple of quick things. To have the trial work, we need at least 2 in-class sessions, preferably 4. What I generally do is run through the entire trial independently with the plaintiffs and the defense team. And then we walk through the whole thing together, kind of like your dress rehearsal, and then we present it to the parents. Now, I'm thinking we can do the teams remotely using Zoom, so that will get rid of 2 required classes. So then we'll only have to have the walkthrough dress rehearsal and then the presentation to actually hold the trial. So we're just gonna move forward as if everything's gonna be great. I've received a couple of Google Drives from people with their questions, with their statements, and I was able to give comments on that, which I'm happy to do. If you send anything to me, I gave you my email address on our last class together. Make sure you put on the title who you are, who you are questioning, and which team you're on. Are you defense or prosecution? Because that makes it a lot easier for me when I review it to look at it and go, okay, this person is doing it from this perspective, and so on and so forth. So that's where we are right now. And what I'm going to do in this video is actually do the teaching that I would do if we were in class. So what I need to go over with you are what are called trial objections. So that's what we would be learning in class, because that's something that you will do when we actually hold the trial. So there are all kinds of trial objections that are used in a real trial. I'm going to limit the ones that you use in our trial to the PDF that I'm sending you. It's posted on my website, and it's also in the email attachment that I'm sending with this video to your parents. So if you have not done so already, pause this video and print out that trial objection sheet so it will have them all listed. Okay, so I'm assuming you paused the video and you printed out your trial objections, and now you have them in front of you. So I'm going to go through each one of them and explain to you what they are, how to use them, and then eventually we will Zoom, and if you have any questions, you can ask me then. But what I would like you to do is take notes. So if you need to pause this video to write down, can you hear my phone ringing? Totally distracting, isn't it? If you need to pause this video to write down what the objections are, to do that. That's an advantage of learning this way, is that you can go at what pace works for you. So, of trial objections, the way they work is in the trial, when the other side is questioning a witness, any of the opposite teams, the opposite side, can object to the way that the question is asked or the way the witness is answering that. And so what that means is there are specific rules on how you have to question. Now, we've kind of talked over some of those because you guys have started your witness questions, but I'm going to go over the objections that someone can raise if they are wrong. Now, when you are objecting in a trial, you have to pay close attention to the question that's being asked and decide pretty quickly, is that an okay question? Can I object to it? Because you have to raise that objection before the other attorney moves on and asks a new question. Does that make sense? So it's kind of a quick thing. Think of it kind of, some of you guys play sports. I have some soccer players, some basketball players. It's calling a timeout on your soccer team. You do that. My son's laughing at me. He's in law school and he just walked by. I should have close the door so he can't hear me. It's like calling a timeout on that sporting event so that the coach can kind of regroup. But you can't call a timeout after a goal has already been served or scored. So you need to do it quickly. So the way you object is you simply stand up, say objection. You get a second or two to kind of get your thoughts together. You knew the question wasn't right, and you can decide which of those things on the list. Was it leading? Was it compound? Was it argumentative? And then you tell the judge, objection, argumentative question, and the judge may look at you and ask why, and you could say, because blah, blah, blah. So we will talk more about that, particularly when we do our walkthrough is when we really practice that. So the judge, after hearing your objection, which we will go over in a second, has two things that the judge can do. They can either sustain the objection, meaning they're agreeing with you, or they can overrule the objection. And so then the question stands. I was doing a mock trial once with a student. He's actually been in like 2 or 3 of my mock trials over the course of years. And one of his very first objections, he stood up and he said, compound objection, compound question. And I said, okay, sustained. And he got really upset and sat down and kind of pouted. And I'm like, you were right, you just won. And he's like, oh, okay. He got confused. So if it's sustained, that's a good thing. That means that your objection was appropriate and the other side has to re-ask the question. So let's go ahead and dig in and go to our questions. I have them printed right here so I know what to talk about first. The first objection is a leading question. When you write out or when you ask a question, it cannot suggest the answer to the question within it. So for example, a leading question is something that has the answer when you ask it. So at 8 o'clock today, or on 8 o'clock on that day, did you go to the deli? Correct, you went to the deli. You're giving the answer in it. You're saying it happened at 8 o'clock and they went to the deli. So when you ask the question, you want to ask it more open so it doesn't have the answer in it. What did you do in the afternoon? I went to the deli. What time did you go to the deli? I went to the deli at 8 o'clock. So it doesn't have the answer in it. In our case, if you were asking one of the plaintiff or the defendant specifically, did you text blah, 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 you would want to ask, what did you text? Not, did you text blah, blah, blah. So they have to answer it. Now, there is an exception to leading questions. On cross-examination, you're allowed to ask leading questions because the witness is considered hostile. So you can give the answer if you're someone who's cross-examining a witness. So that's kind of what a leading question is. The next type of objection you can use is called, I should have my son do this. Have you taken evidence yet? Okay, there's a whole, my son's in law school, you've heard about that. There's a whole class in law school called evidence. I know, there he is. Poor kid, he's home, his law school's closed. He's never been home for more than like a week or two since he was graduated from high school, and now he's home till September, poor boy. So in law school, you do a whole class on this, and he asked me if I wanted something to eat. No, thank you. And so you're getting just the highlights. So the next one, compound question. A compound question is a question that asks 2 questions in one. So you can't ask something that has an and or an or in it. Let me think of a good one that would be like, did you go to the store and rob it? Well, what's the answer? No, I didn't rob it, or yes, I went to the store, but no, I didn't rob it. So it gets confusing that way. So you want to ask a question so that it only has one answer to it. Because if you ask, did you go to the store and rob the store? And the person said no, then you could go, you're lying. You did go to the store, and we have this evidence that shows that you went to the store. Does that kind of make sense? So one question at a time. So we did leading questions, compound questions. You can't ask, and then the next one is a narrative answer. And you can object to that when a witness starts going on and on and on and on. Like, you don't if someone were to ask a question, what happened? And they go, well, I got up in the morning, I made breakfast. And then after I made breakfast, I got in my car and then I went to the store. And when I was at the store, I saw somebody and then that person stole a candy bar from the store. See, they're narrating, they're going on and on. When you ask a question, the question has to have a simple answer to it. And so you can ask a question that's too open-ended, which would be a objection because it calls for a narrative, or the witness can answer the question in such a way that they're going on and on and on, and so they're giving a narrative response. So you can object because the response is narrative. Kind of, you'll see as we kind of start working together with the questions, because I'll be pointing stuff out to you. Sometimes I'll say, oh, I really like that, but the other side may object to it. So just be prepared that if they're on their game, they're going to object to it. But that doesn't mean that you can't try it. Another thing that lawyers sometimes do is they make objections just to kind of break up the flow, kind of the way that in a sporting event they do a timeout. If the other team is scoring too many baskets, they'll go, okay, we need to stop this, we need a timeout. So objections can even be used that way. You kind of want to be careful in that because you don't want to irritate the jury or the judge. So you want to use that very sparingly, but I have seen it done and lawyers can do it very effectively. So we called for a narrative, our narrative answer. The next one that I put on the list is an argumentative question. And that's something that sometimes you've seen on TV shows called badgering the witness, when you're arguing with the witness, where you say, how can you sit there and lie to the court about your attitude, or you're being confrontational as opposed to just asking a question. So that's argumentative. The next one is asked and answered. And we've talked about this when we were in class and we were working. You don't ask a question that has already been asked. For example, on cross, I had told you guys, no, you don't need to lay the foundation. You don't need to ask the witness what their name is, how old they are, because we know that will already have been asked and answered on the direct examination. So you just want to pay attention that you're not asking questions again that have already been asked and answered. And when you cross-examine your witness, you guys, this is the trickiest part, because you guys who are doing cross are going to write your questions ahead of time, not knowing what will have been asked on direct examination. So it's possible you will ask something that the other attorney has already asked. So you got to use the big brain and go, oh, I don't need to ask that. It's already been asked. And if you do ask it, because sometimes I've seen students just go, I'm going off my list, and that's okay. You guys, remember, this is a high school trial that you guys are doing because you're very capable of doing it, but it is a high school level trial. I will see students read off their list, which, like I said, is okay, but it will draw an objection to other attorney who's paying close attention and realizes, hey, that question's already been asked and answered. So we have leading when it has the answer in the question. You have compound when there are two questions together. Narrative when it calls for the witness to ramble on and on, or if the witness does ramble on and on. I've seen people, some of you guys, when we were working together, would have a question, but your witness's answer would be narrative. So if your witness is planning on doing that, keep in mind that they could be objected to, asked and answered. Another thing, the next one on your list, and I hope that you guys are kind of stopping as you go along if you need to make some notes on this. The next one is called non-responsive answers. And that's when the witness answers something totally different. You know, like in our case, it's like, where did you go together? And it's like, oh, he said I was not nice. No, I asked you where you went together. We went to the go-go. It's not, he was not nice to me at the go-go. So if the witness answers a question that you didn't ask, like where did you go, and they tell you what happened there instead of just simply saying we went to a go-go, that would be considered non-responsive. And so again, a smart attorney who's paying close attention is listening to the question and paying attention did the witness answer that question? Now this is a really good objection to use, because you will often have witnesses who will just kind of go off on things that aren't what was asked. And sometimes it can help their case, and you don't want the other side's case to be helped. So you want to object right away. Objection, Your Honor, non-responsive. The next one is lacks foundation. And we've talked about that in class too. You don't ask a question, what happened there, without establishing where did they go. So back to our example of going to the Agogo, the kid hangout place in our case, you wouldn't just ask what happened. You would want to say, where did you go? Who was there? What happened when you were there with that person? So you're laying the foundation. When we're talking about some of our witnesses, one of you was writing about the school psychiatrist who had diagnosed one of the witnesses, the plaintiff, with PTSD. You have to lay the foundation that they're able to diagnose with PTSD, how they diagnosed with PTSD, and did that particular plaintiff have PTSD. So you need to lay that foundation. And I know I've talked individually with different students about that. So we have lacks foundation. The next one on the list is creation of a material fact. In our case, we are limited to what is in your trial notebook. You are limited to those affidavits, the statements of fact. You can't make up stuff. You can't go outside of the scope of the information that you have in your trial notebook. So if one of the parties were to ask a question that's outside of the scope, you could object and say creation of a material fact. Like I've had people say, you know, ask stuff to the parent of the plaintiff, and what did you think about this, or how did he do that? And hold it, it's not even in there. You can't ask questions that are outside of the facts. That's why it's so important to be very familiar with the facts of your witnesses, so that you know if someone's trying to go outside of that, and you can object to that. Because if you don't object, they can ask whatever they want. I won't stop them as the judge. That's your job to stop them if they go outside of a material fact. And then the last thing on the list, and I'm throwing it in there, it's very complicated. It's called hearsay. And I just want to expose you to it, but within our trial, I'm not going to make a big deal about it, because it's called the hearsay rule of evidence, and there are a lot of exceptions to it. And like I said, when you're in law school, you take a whole class on this, and this is a huge chunk of that law school class, is the hearsay rule and the exceptions. Hearsay is basically repeating what someone else said. So in a real courtroom, you cannot testify what someone else said. You can only testify what you saw. You can testify, and you're like, well, hold it. Can't we testify that this person said this that was unkind? Yeah, if it's a statement against their interest, if that's a material fact to the case, if it was an excited utterance, if it was done in the heat of the moment, if it's, there's a ton of exceptions to hearsay. And so within this case, if you were to ask Alex what Pearson said, it would be an exception to the hearsay rule, because it was he is the defendant, and so it would be a statement against his own interest. And so at that point, because he's a party to the case, you could use it. So it's complicated, we're not even going to get really into hearsay, but I feel like if this is a mock trial class and we're talking about objections, hearsay is probably the biggest objection that's used in a real courtroom. So I feel like I needed to kind of at least tell you guys about it, but you can even make a big zero through it, because I don't expect you to use it in this case. Make sense? So there, you just got an overview, super fast flyby view of the trial objections that are most commonly used and the ones that we will use in this trial. When we do our trial, I will have them printed for you, and they will be in front of you. You don't have to memorize them. You don't have to really super stress about it. Be familiar with what they are. Once we walk through as your team and we walk through as the entire trial, you will have heard them more times and seen how they really work. So you're probably going, Ms. Chappie, you're freaking me out. I don't know what you're talking about. But I promise you, it becomes a little clearer. You want to pay close attention to compound. You want to pay close attention to leading. Now remember, leading, the exception is on cross. You can lead on cross, just not on direct. So that's my spiel. You heard it. That's my spiel on trial objections. This week, we're not going to meet via Zoom. We're just your job is to listen to this, to write down the summary of each of the objections, and to go over your witness statements. If you're a witness, you need to read that twice this week. And if you're an attorney doing direct, you need to work on your witness statements. You're like, but I don't have my witness. That's okay. You don't need them. You have your statement, and your witness is going to be working on being more and more comfortable with it. And then if we continue to move forward, which it sounds like we're going to, since we have 11 out of 18 that want to do it, I will have to learn how to break into Zoom rooms, and we will do that together. So that's the end of my story. Have a great week. Thank you guys for hanging in there, and I look forward to working more with you. If you want to reach out to me, send me anything, you can do that. I will get it back to you. As you can imagine, there's a lot going on with administration of FLA and getting all these classes online. So I appreciate your grace and your patience, but I think it's going to be good. So have a great week. See you guys later. Hit stop. There you go.